Welcome, everyone. Good morning. And let's kick off the second day of the conference, third plenary conference by Professor Eduardo Oteiza, professor at the master's career in the Universidad de La Plata, Universidad de La Plata in Argentina. He's been the president of the procedural law career and institute, and since 2019 he's the president of the International Association of Procedural Law. He did the Jean Monnet program at the Institute of Law in Europe, and he was also in the University of Bologna and the German Association of International Cooperation. Between 2016 and 2019, he was part of the consultory committee of the 2020 program of the Ministry of Justice in Argentina to draft the National Procedural and Civil Code. He's been invited lecturer at many universities, including Turin, Bologna, Genoa, York, Firenze, Medellin, Pompeu Fabra, Pontificia of Lima, and the Max Planck Institute in Luxembourg. In 2016, he got the award Enrico De Venti for his career in the field of civil procedural law. Today, he will be given a speech presentation which is called Michele Taruffo, How to Compare in Probatory Matters. So, Professor Oteiza, you've got the floor.
Buenos días a todos y a todas.
Welcome. Good morning, everyone. It is a great honor to be here. First of all, I would like to thank Jordi Ferrer. And it's not just him, but a whole group. Carmen Vázquez, Diego Del Luequi. The names would go on to so many people working in this place and which make this place so beloved for so many reasons. And also my personal acknowledgement to him, because when we discussed some time ago what the topic should be here, I wanted to talk about compared law, but I had the doubt of how Michele Taruffo had done his job, his comparison job. So this challenge brought me to find him again, to meet again with him and have this new vision on his texts, which in the daily routine and in the many moments we shared was different, was another dimension. So my second acknowledgement here is for allowing me here to give in my way an explanation. It would be trivial to discuss the prestige or the reputation of Michele Taruffo, but I would like to try and walk the ways he walked in two different fields. Compared law, but referred to the proof, to evidence. Michele Taruffo studied in the field of law, philosophy, and precedents, and potential reforms to procedural law and evidence. But the combination of Michele Taruffo's vision in the field of evidence and compared law, at least I had some doubts about that. So I will start this introduction with something I thought I would call intimate science, although not so much. Not so much means it's about certain intimacy some people shared with him. And this was at the same time intimate, but also shared with many people. And then secondly, I say this is a work under construction because these intimate moments are about the personality and the insights of Michele Taruffo in his studies, with which he got to make this work under construction. And this idea of a work under construction links the idea of the start of my presentation with the ending. So I should start with the ex libri because Michele was a bridge between generations, and the ex libri symbol which was presented in the previous edition of this World Conference is a very good representation, and it also conveys this feeling of bond between generations, people, and subjects of study. So the second step for this started in 1992 with that meeting described by Jordi Ferrer in a conference, in a law philosophy conference in which Paolo Comanducci introduced Michele seeking to translate his book on process, procedure, and evidence. So a task started there. I'm just going to summarize it here, but I believe that the line of development is relevant because after 1998, then in 22, the dissemination of the evidence of the fact was done after the joint work between Jordi Ferrer and Michele Taruffo. And after that, something came also in this place, which was the collection on philosophy and law, which we find every day in the exhibition outside of the books and the presentations. But that was part as well of this joint task. And then came another book I will refer to, Michele Taruffo's book, in which he displays his comparison criteria in his book on evidence. And it's got a particular story I will also tell, but that's also that book is also part of Girona, and that coexistence of Michele with the Girona group and many other people. Then the collection Process and Law came, and Michele was part of the steering commission, and you can see him on the cover of the books as well. Then came the judicial culture tenure at the university, and he added the term culture here, which is going to be very related to the developments approached by Michele in the field of compared law. And then, by chance, also there was the opportunity that Michele Taruffo retired in Italy, so he left the university then. He came to Girona, and also it explains well, this coming here to Girona for Michele explains many of the things we are living here. So in 2015, there was the tribute, homage to this very particular tribute to Michele Taruffo, because the invitation, as Jordi Ferrer will surely recall, he called each one of us to speak in that conference, and he said, I would ask you to oppose Michele, not to praise him, but to see what in what he did, in what he had done, you didn't share as an opinion, as a position. That was no easy challenge, because after every presentation, Michele would stand up and speak. So that was a very interesting dialectic exercise with Michele. But in that tribute, the highlights were the evidence, law, philosophy, and precedents, and compared law. These were the three main topics on which the work of Michele deals with. So in 2020, there was the Quaestio Facti, another conference, then the Michele Taruffo's fund that came to Girona, and I will refer also in my compared analysis to this rival of the fund here, which is more than a library, it's a library and art. very interesting combination. Then the first edition of this conference was in 2022, and the second one, here we are. So this picture is about the fund Michele Taruffo getting here. So what about the perspective, the choice of tertium comparationis, and the risks of simplifying? What to compare and how to compare? I will start, and I will very shortly to deal with this challenge. An article published in the Harvard Law Review on the functions of compared law, a critique on the philosophy of case law written by Pierre Le Paul. So in this article, he signs as a lawyer in the Court of Appeal of Paris in this Harvard Law Review paper. So this message is going to link forward with something I will say in the end. So he said in the end of his paper, to see things in the true light, we must see them from a certain distance as strangers, which is impossible when we study any phenomena of our own country. So the need in the beginning of the century to compare is very well conveyed in this conclusion of this work, the need of the comparison expert to draw back from the system to see it with the power it really has. The second idea I would like to share with you, the second picture, is another work at the American Bar Journal, the American Bar Association Journal by Roscoe Pound. What we may expect from comparative law. And Mr. Allen will forgive me to bring up Roscoe Pound here because he was part of our discussions with Michele Taruffo, where we discussed the validity of Roscoe Pound's quotes. And this work is from 1996, but it goes back to the ideas of Le Paul. And in the first lines of this work, he quotes the poet Matthew Arnold, and it says, in just a few words, that who knows only their Bible knows very little about their Bible, which means the need to open up to the challenge posed by compared law. And there's a very famous sentence often quoted in comparison fields, in which he said, as I said at the outset, much if not all depends on what we mean by comparative law. What is compared law? Upon what is compared and how it is compared? So these two questions will basically help me develop my vision on Michele Taruffo's. Of course, this is a transcendent, complex challenge, and the prevailing theories in comparative law approach this in a different way, and all of them with a lot of caution. There's some preponderance at some point, which necessarily tends to compatibilize with the others, and I will tell you how. As you know, comparative law is a recently new science, not the task of comparing, but the scientific independence, if you wish, of comparative law was born in the Paris conference in 1900, and then it was developed. That was the time of the World Exhibition in Paris. The power of France at that time was not so much afterwards. So they started developing, mainly in the discussion between the civil code of France and Germany. They developed all the theories on how to compare and what to compare. So from that time, the conclusions or the main theories of that time were the division between the families, the judicial families of David and Briley. And this really prevailed in the compared law of that time, and it still prevails. We still discuss and talk about judicial families, and in comparative law, there is a general consensus between scholars that this division of the world made by René Davide, talking about civil law, common law, Islamic law, and others, to refer this classification of the world based on families, but this was not compatible with more complex development. So after this theory of judicial families, and after it started losing weight, came the idea of Merriman on judicial traditions. That started in 1969 with law traditions. So he basically brought more complexity inside each one of the families. It was not so much about classifying, but about understanding what was in each one of those families. But besides the judicial traditions, and I will be quick about this because I won't have time otherwise, the functionalist ideas were brought up. The idea of systematizing the functioning of institutions and how some institutions are compatible with others, and to what extent is it possible to adapt and examine how these institutions work in diverse contexts. And then there was a discussion, and still is, when you bring tension into this idea of functionalism which prevailed over the 70s, the work by Zwigert, with the idea of culture. Culture started, social studies on culture started as a significant initiative to see what to compare and how to compare. And Pierre Legrand was and Friedman were prevailing figures because they integrated into comparative law the need to see where these institutions are developed and how they are developed. Of course, this brings about tensions and global phenomena. And all of these concerns are close to me because the PhD course at the Pompeu Fabra University was giving this course, and one of the best ways to learn a subject is to teach it. And the challenge to teach comparative law allowed me to find out that when I was comparing, I didn't know so much how to compare. The theoretical way of comparing was not so present in me. And there are some effective tensions in comparative law. One of these tensions I would like to underline is between globalization and then local, between local and global, between the parish and the world at large. So boiling it down to your county, to your small place, or making it global. And these two notions are in a constant tension. One does not prevail on the other, but they coexist. Same thing with the idea of universalism and particularism, which was also very much present in Michele Taruffo's analysis. He actually discusses the notion of precedent, and he discusses as well a lack of response from the president, and he criticizes it because he thinks there's some universalist trend. There's a groundless universalist trend. Also, another issue analyzed by comparative law scholars and rejected by them is the idea of transplants, judicial transplants, which struggles with the idea of harmonization and the mistake that comes with trying to transplant an institution in a different context. And this goes together with the critique to Eurocentrism and decolonization that also instill the visions of comparative law scholars. And also the idea of context, of current context, neo-constitutionalism, and what are the values of the system. and also more hot issues, more pressing issues, and democratic rescission, democratic termination, as has been discussed with Raymond and others, and they point out that democracies do not drop, do not fall all at once, but they gradually lose their essence and they dematerialize into autocracies. And law operates as a system within these challenges. Then last, about methodological and epistemological issues of the comparison, the difference or the compatibility and the balance between macro comparison and micro comparison, the problem of language within compared law, and the appearance of neutrality in the compared analysis, which is often not so. So this background made me think when I got the invitation to this conference, what these three axes of the problem, how were they managed by Michele? How was he able to think about an institution such as the proof, the evidence on these different levels? And so I will move on to the third point, which I will develop further, which is the personal selection of some fundamental highlights and the work of Michele Taruffo as a multidisciplinary comparative law scholar. So there's this book, one of the main ones, I believe, in comparative procedural law, which is volume 16 of the International Encyclopedia on Compared Law, on about the around the 80s or 90s. It approached the challenge to procedural law experts, that generation of procedural law experts, to somehow approach the civil procedure from the perspective of compared law. There has not been such a great work as this volume 16, directed by Mauro Capelletti. He was the chief editor of that volume.
In the first chapters of volume 16, one may find excellent work by Capelletti with Nar on the various visions and dimensions of comparative procedural law. This is an excellent study carried out by Van Cannigan on the history of civil procedural law, and I must emphasize it's only European, okay? But funnily enough, this is not just a European essay or study. It also offers some glimpses into comparative law in Latin America. I would also like to highlight the study by David Clark on the organization of lawyers in the area of justice. But clearly, the most important thing about this generation of comparative procedural law experts can be found in this volume. Sometime later, and I must say that I have been quite privileged in this regard, Michele came to Argentina and he gifted me this, what you see on screen. This is the cover of chapter 7, referring to evidence. And Michele is included as one of the highlighted authors. And how could Michele do this to provide analysis, a comparative analysis on evidence? Well, that chapter has a very particular story that I became acquainted with thanks to Jordi Ferrer. This was first published in Spanish, because you know that the publishing house delayed later publication, so it was decided to publish first the book in Spanish as part of the philosophy and law collection, entitled Evidence. But I was even more surprised when finding in the library something that had been there which I had not seen. It's the following. This is the same publication in Persian. This is a book that you will not find in any other library outside of Iran. It might be here now, but this is evidence in Persian. And it was translated by Hassan Mosseini. And interestingly, it was published in 1398. It's not that it's a medieval work. This means that the Persian calendar imposes that kind of date. But clearly, this faces us with a different vision, with complexity. This is a publication that one would start to read the other way round. You know, the cover is the back, and it reads in reverse order. Obviously, I cannot read Persian, so I had to ask a dear friend of mine from Iran who lives in Canada, who has authored different publications, and he's a member of the International Association, and I wanted to know more about the origin of this publication. And after conducting a search, I was able to see that this could not be found in any library outside of Iran. This book, the book on evidence, is a book in which Michele combines 5 elements: evidence and truth, how evidence is selected, types of evidence, procedural features of evidence, and lastly, how, based on evidence, one can reach a final decision. But the book starts with a strategy, a comparative strategy dedicated to chapter 1, revolving around the issue of truth. Clearly, he refers to the various experiences in comparative law in a very well-informed publication, but the core, his real interest, is into evidence and truth. So based on this publication, I thought it was necessary to take a step back and to have a look at what the beginnings were like. You will probably know that in the previous edition of this Congress, Luca Passanante announced and presented the Laudia, Michele Taruffo's thesis on the contribution to maximum experience. And in the introduction, he explains something quite singular. He goes on to say that Michele Taruffo at the Liglieri School followed a course on deontical theory and logic, and in that course he came to know someone closer to him, belonging to the same generation, Amadeo Giovanni Conte, with whom Michele tried to start his career as a philosopher. Conte was very young. He could not offer him an academic career to Michele then, so he suggested to him to work together. And they recommended working with Vittorio Denti. That book was retrieved from the memoirs of Luca Passanante, and together with Jordi Ferrer, one first analysis of the book was carried out. And obviously, the publication of it, translated by Andres Ibáñez, was perfectly necessary. Published a few years ago, by the way. Then, in 1970, we saw the publication of the book on relevance of evidence, published again in 2023. And let me share with you another very interesting piece of data. Some opinions on Michele Taruffo, the iconoclast. Let me just say also that in the previous book, in his first book, in his dissertation, Michele started by hardly criticizing Spain and the entire Italian school because of their lack of critique on the maxims of experience. And when it comes to Michele's opinions, Giovanni Tarello, a philosopher, said that it is an excellent monograph on a topic of civil procedure, very difficult, and a notable contribution to the theory of law. Salvatore Sata did not share the same view. In the Quaderni del diritto e del processo civile, he said, I'm not interested in Taruffo's book unless although he is a young person, indeed with capacity, but deviated from current trend, but he's reduced law to a mere game. I think he made a mistake in his criticism to Taruffo's work. Years later, the publication of the title, of the publication 43 years later of Taruffo's work demonstrates he was wrong. Now, chapter 2 of that first or second book, depending on your own interpretation, was judgment of relevance in civil law, common law, and in socialist countries, where Michele Taruffo started to develop very clearly the idea of a need for comparative law. I think I'm okay for time, aren't I? Okay. So this idea of legal schools and the relationship between masters and disciples leads me to a second very important publication by Michele Taruffo. I think this happened in the first institutional congress of the International Association of Procedural Law as we know it today. This happened in 1972, where the International Association in Mexico started to be shaped as such. In the past, world congresses were indeed held, but there was no formal constitution of the organization. It was just an initiative with Alcalá, Zamora, Mario Capelletti, and Marcelo Stormer, those that ended up giving new life to the International Association of Procedural Law. And in the renowned book, because of a quote that is usually referred to of that congress organized by Marcelo Stormi, reference was made to a justice with a more human face. And there's a very interesting work on comparative law about the administration of evidence in the legal system, published by Gian Antonio Micheli and Michele Taruffo. And this publication on comparative law places a very young Michele Taruffo, with 30-odd years old, at the same level as Michele, who was already 30 years older than him. Nonetheless, they shared the authorship of that comparative law work with analysis of national work. It was an excellent publication, and this was Michele Taruffo's first step in the International Association of Procedural Law. It followed in 1979, that is 2 years later, Il processo civile adversari sull'esperienza americana. Here, Michele Taruffo started to take as the tertium comparationes what happened in the United States. And chapter 1 is focused particularly on the problems posed by evidence in the context of the adversarial proceeding in the US. And then in 1993, we saw American Civil Procedure, another publication. It is said it was written by Jeffrey Hassard, Michele Taruffo, in 1993. And it starts with the first chapter analyzing the evolution of this system in the United States. Another publication that seduced me, one becomes enamored with books for many different reasons. The main appeal of this book was this quote. I tend to quote myself sometimes or copy some things I do because it reveals the position of Michele. And on the first page, Michele includes something that is distinctive, and he says, well, Jordi Ferrer asked me not to mix Italian with Spanish. not to drive our interpreters crazy, but I believe the interpreters will understand this. It goes on to say,
a ti, scoprirai che non esisteva. La sola idea
the mere idea of approaching the confines, the limits, breaking through and seeing it does not exist, is a challenge that compels us to look beyond. And between brackets, we see something that it wouldn't be Borgian. It says from the apocryphal diary of Genghis Khan. Can there be such a diary? In any case, Michele believed it did. So this led me down a different path, which I believe reveals some of Michele's thoughts that can be found in this quote of the book. Calvin and Invisible Cities. There is something in that quote. One could read books and try to understand what the books describe. One may find special dialogues in these books, but in my opinion, there is a clear relationship with that quote included by Michele Taruffo and Calvin's book, as well as the challenge to compare. In Calvin's book, there is something which I believe is very, very relevant. It brings together a grandfather with his grandchild. The grandfather is Genghis Khan, and the grandfather is Kublai Khan, and the grandson is Kublai Khan. Excuse me. And it goes on to say, after dawn, when the dawn is like the end. It's not sunrise or the opposite. It's a point in between. In the terraces of the Royal Palace, Marco Polo showed the result of his travels. Usually, the great Khan finished his nights savouring with his eyes half closed these stories until he started to yawn, and that was the signal for his staff to switch on the torches to guide the sovereign to the pavilion of sleep. But this time Kublai did not seem willing to fall asleep. And here is the comparative message.
insisteva. Era l'alba quando disse: Sire, ormai ti ho parlato di tutte le città che conosco. Le decía, dime ahora.
So he said, now tell me another city. It was early morning when I said, Sire, I spoke to you about all the cities I know, but there's only one left, of which I've never spoken about. And Marco Polo assented, saying, Venice, said the Khan. Marco smiled.
Vi che ti parlassi. El emperador no pestañeó. Marco sonrió.
Marco smiled, and he said, what other city do you think I was talking about? Nevertheless, I never heard you pronounce its name. And Polo said, so this links looking at things the way they are and understanding. There's always a subjective point of view. We always speak about our own things. We'll always find a bond with the end. So in that book, there's a publication called Transcultural Dimensions of Civil Justice, published in Spanish, in Italian, and in English. In English, it is published in Transcultural Dimensions of Justice, in the Comparative Law Review in the year 2000, also published in the Quarterly Journal of Procedural Law in that same year. What interests me about this work is that in Michele's last publication, Verso la decisione giusta, chapter 6, I believe he was entirely convinced in that that idea represented him. The idea of the transcultural dimension of civil justice. When paying tribute to Taruffo and Steve Bourbon, who worked on the Michele Taruffo as a comparatist, he precisely referred to this publication by Michele Taruffo in the year 2000. I will get back to this later. Michele Taruffo, in Note 1 and Note 3, refers to Friedman in The Horizontal Society and the Republic of Choice Law, Authority and Culture, and also in Is There a Modern Legal Culture? These are books that opened up a cultural path or sphere. Michele Taruffo's work refers to the principles of procedural law, transnational procedural law of Unidrat Ali, that establish a link with the model code referred to Carmen Vázquez, and a third project, which is the Eli Unidra Model European Rules of Civil Procedure. So one may say that they might not be able to be applied in states, but I think that these projects have the undeniable advantage that they have been written by knowing the reality of the countries, but with the expectation of an academic, of improving a situation and not falling victim to many of the conflicts that need to be overcome when one needs to adapt a structure, institutions, or others to a certain structure or justice. Now I'm getting to the end, but let me get back to Girona in 2015 and the title given to that Congress, which was Multidisciplinary Legal Expert. This was entitled How to Discuss with Taruffo. There are two relevant discussions about Taruffo as a comparatist. The first is the one referred to by Steve Burbank on process and pragmatism. Steve Burbank analyzes the work about transcultural dimension. He criticizes it, and he says that in Michele's vision, he lost sight of the changes operating, especially in the class actions and in the way of litigating by lawyers. And he goes on to say how there has been a policy of incentives that determined a change in this sphere. In that meeting, Michele said something that surprised me. He said, "Only stupid people never change." He recognized that the vision of that work could be reasonably observed, which seems to me a clear example of academic humbleness. He didn't grasp to a defense. He did recognize that some of those questions or matters, the Kian book was not there yet, but some of the matters that he had published about at a given time did not respond or did not account for and were unnecessarily abstract vis-a-vis the iconoclastic remarks and observations as described by Burbank on individualistic altruism, which he believed was an abstraction that did not respond to comparatist criteria. He also referred to the particularities of class actions, and especially following the legislation in the 60s and 70s in the US. They were seen as so-called structural processes. A second criticism by Ronald Allen on the danger of investigation in comparative law against Michele is that there was a lack of empirical demonstration, and also about the insufficiency of analytic speculation. He also emphasized something that I share, which is Reading codes or choosing a few authors does not suffice. One must delve into the reality. Inasmuch one carries out this task well, it depends on the limits and striking the right balance between the various elements. He also referred to a rhetoric position on the American process, confronting it with the European one when it comes to the degree of the search of truth of one or the other. So when faced with this reproach, I think Michele defended his position quite well.
About the problems and the dangers of comparative law. I am skeptical enough about comparative law, although I consider myself a comparativist. But I'm skeptical enough because I know how much bad comparative law is done in the area of civil procedure as well as in many other areas of the law. But one thing is comparative law is a difficult enterprise, has dangers, abstract comparison is nonsense. One has to take into consideration all the factors conditioning how a legal system of procedure works. Well, okay, history, culture, institutions, political factors needs to be to be taken into consideration. But let's pay attention not to push all this too far, because if we do that, we conclude simply that comparative law is impossible. And as a comparativist, I cannot share this conclusion, because I am accustomed to believe, as many comparativists do, that one of the best ways to know your own legal system is to look at it from the outside. And looking at it from the outside means to compare your system with the other systems, which is not the problem of saying civil law is better or not better than common law. This is thinking that way is stupid. And although I am very critical considering the American adversarial system, I'm not saying that the civil law procedural systems are better. I know a lot of bad civil law procedural systems, but this is only to stress the fact that they are different. Now, from the point of view, the less general one, from the point of view of the search of truth, we can analyze different systems in order to say this is more truth-oriented and this is less truth-oriented. Because if I am considering a system, as the Italian one, for instance, in which we still have rules of legal proof, and we compare this aspect of the system with other systems, as the American one, that don't have rules of legal proof, when I am authorized to say that the Italian system, from this point of view, is less truth-oriented than another system. Because if we don't work that way, simply as I said before, we should conclude that comparing legal systems is stupid and leads to nowhere, which is not. Because in the experience of the good legal comparison, we learn a lot about other legal systems, as I learn a lot as a comparativist about my own Italian legal system.
Well, now let's draw some conclusions based on Michele's position. What does compare bring with it? It's not a neutral or innocent operation. It entails taking position, establishing a framework, taking on epistemological risks. It is clearly difficult to compare. So much so that the book published in Persian demonstrates that. How can I understand a language that does not exist, right? And there are certain degrees in the way one can approach such a matter. And in general, it is not a neutral or an innocent operation that is to bring visions that, as Marco Polo does, we can always refer to Venice from a different point in the world. So what factors need to be considered? We need to consider the historical context, the legal language, institutions, social functions, legal culture, empirical data, and many, many more. It is a complex challenge and a difficult one. So amazing as difficult that it is. Now, the apparent comparison between difficulty and impossibility shows that comparison is not impossible, but it is deeply difficult if one takes it seriously. The difficulty should not be an excuse to neglect, but it should not be a justification to simplify.
Algo que dijo.
This is something that is very powerful. There's nothing that's better or worse, because comparative law is not a competition or a hierarchy of systems. Comparative decisions and judgments mean tackling prejudice. There is no superiority. There's not something that's better than something else. It's just different things. And in the theory of comparative law, we have to pay attention to difference. This is key. And this relative predominance disappears when you face the problems, i.e., how can I analyze, assess a native community within a more evolved society if I still have this prejudice of dominance? The tertium comparación is chosen by Taruffo. The adversary civil process in 1979 led him to his book of 2020 regarding just proof. And this was an exercise of consistency. And this is, for me, the key message of Taruffo's presentation. And we are talking about bridges that will join two different sides. And this was one of the key messages of Taruffo, to be able to compare proof. Thank you.
Muy bien, pues muchísimas gracias.
Thank you very much, Professor Oteiza, for your magnificent presentation. We will now start with the Q&A. First of all, we have Professor Jordi Ferrer Beltrán, who has the floor. Thank you very much, Eduardo, for giving us this review of the work of Michele Taruffo and his perspective on evidence. I would like to provide you with a different perspective, although it's not an incompatible perspective. I'd just like to know and see how you would judge this. I don't know whether this idea of the multidisciplinary jurist is the best perspective, or maybe we should be talking about a polyedric type of jurist. But I do think that there is a dominant perspective in Michele's work, and it's not that of a comparativist. It's that of a normativist. I believe that Michele Taruffo liked to say how things should be. That's what he liked best. But to be able to say how things should be, he, I think, thought that it was important to know about the cultural context, the context of standards, the training of the players playing with that legal toy, the political context, i.e., the way that things should be, is not an exercise of imagining at your desk in your office of how things should be designed in abstract. You have to take into account sociology and other systems and other realities and other problems and the complexity of the system in this regard. And this is an approach similar to that of Ron Allen. So to see how the different pieces of this system work together. And therefore, I think it was necessary to have all these different ingredients in the first place. And I think that his last book was consistently so in the sense that it was decisione giusta, the just decision, i.e., what should we do? Where should we be heading? And this is a normativist point of view. It's based on rules, on standards and regulations. And this, I believe, plays a key role. I'm not saying that most of his work has this aspect, because there are many other aspects. There are many other elements from other disciplines, political, economic, and so on and so forth. But all of these were ingredients to be able to give a reply to the question, what type of law should we have? And this means that the comparative ingredient becomes an additional tool in this further analysis, or in this further perspective or final perspective that I believe he always had in mind. But I would like to get your feedback on this. Yes, I have my doubts on whether we could say that he was normative. I think that further beyond the normative concept, he was always concerned about the just decision of law. And it's no coincidence that his book is entitled like this. And it's no coincidence that Laurean's thesis refers to experience, because experience is a non-justified criterion, because he used to refer to likelihood and probability. And he would do that with a purpose. So from that point of view, I could share with you that there was a search of a solution that could be considered as a dogma of rules, a normative dogma. But so many pages of his work show much more color. They show much more contrast. His work went through a lot of evidence and proof on the same idea. And this is something that stands out. And he was convinced, and I think that's one of his virtues, because there were no attempts to approach problems, but a clear approach, not an attempt of an approach. He would always have a clear goal, and then he would learn in the process. Then he would be developing further his ideas. It is true, though, that the just decision is an example, but there is a previous criterion, i.e., his work with the Villafil work and the idea of having the structure of a cohort and the value of the president, because the president does lie on a decision that for him should have a considerable degree of truth. And I don't know whether I can share with you the idea that comparative law wasn't that important to him, because he transformed his vision through this comparative approach. And this is my own personal opinion, but in this way, maybe I'm challenging what happens often when you don't agree with what you have. You look for other realities outside, because sometimes our own systems don't give us those answers. And Michele would go further beyond Italy to understand Italy. He never denied his belonging to his own national system, but the national system offered no responses. And in this regard, I think that both Mauro Capelletti and Michele Taruffo went along the same paths. They went to find ideas where they couldn't find them in their own countries. And luckily enough, they maintained their own vision, but looking from the outside. And maybe the purpose was a purpose of standardization, a normative purpose. But we see multiple experiences in a very enriching voyage that is reflected in these many and very colorful pages. And it's his work. All these pages show a lot of consistency. This work shows this path. Thank you for your question. Let's continue with the questions that we received in writing. If we look at the reproduction of systems, for example, in Latin America, using AI for standards, is this new regulation, transplantation, a new way of colonizing countries? Is there a place here for comparative law? I will start with the end of the question. Yes, there is a role to play by comparative law, because comparative law has been focusing on the Eurocentric positions. And Eurocentrism doesn't just refer to Europe, but it also refers to these relationships of dominance, preponderance. And Latin America is a region that is full of transplants. In fact, my first, and this is a personal story, but the first time that I had to work with Taruffo was in a debate in 1998 by the International Association in Turin. And we had to work on the concept of the abuse of the process in Latin America. And the rest of my colleagues had to speak about Japan or Spain or Portugal, but I had to speak about the whole region of Latin America, as if the whole region of Latin America was just the same thing, whereas we have many different cultures, and this has to do with the multicultural concept of Taruffo. Of course, this transplant is in synchrony with other ideas, such as cross-fertilization and harmonization. It depends on what we take for the assessment. What are the roots, the how? For example, Latin America, since its independence, has been living in a hybrid system, because usually Latin America is associated with a consequence, or it's considered a consequence of the Spanish Empire. Almost 300 years of dominance. But here, very often we don't pay attention to the role of the United Kingdom in the 1800s and what was the effect on the Latin America constitutional systems are more based on civil law and common law. In fact, in Argentina, our constitution is just like the constitution of the US, and our courts are like the US courts. And the case law in Argentina is based also in US case law. And we also have different areas that are copied from America. So we have our own national systems, but we have the court that follows the constitutional control of the US. And this is reproduced by the Federal High Court in Brazil and in Mexico, in many countries where institutions have been adopted. Is this good or is this bad? Well, it's neither good nor bad. The reply is much more complex. We should be thinking, why do we think it's good or why do we think it's bad? And then we should start then the discussion. And in this way, we can have a more enriched dialogue. To which point do I want to reach? Which point do I want to reach with this institution? How compatible are our ideas with this institution? It's not a question of stating whether it's good or bad. That's not enough. That's very little, although it's still a conclusion, a likely conclusion, because this transplant may be wrong sometimes. And Latin America has been uselessly fertile in many things. And this is one of the things. And just give me one more minute, please. Because Latin America, one very important thing is the democracy in the 80s when it starts having democracy. There was a very serious economic crisis. And what happened back then? Well, the World Bank and some international agencies would be providing aid, imposing their own models, and that is an inappropriate transplant. And there were many transplants like that. But that doesn't mean, though, that we can only work with the things that we have inside. We also have to see what's outside. Antonio Enrique Graciano Susberger has asked to speak. If he could raise his hand, please. There we go. You have the mic. Wonderful. Thank you and congratulations. I'd like to ask you about the regional systems of human rights. Do they have a deontological role, or is there a risk of being excessive? This is a very interesting question, but I'm not sure whether I have interpreted it right. Could you clarify the question for me, please? In one of the workshops that my group has proposed, we are referring to the jury court, and there is the Human Rights Court that has set some limitations regarding the motivation for the court sentences. And there was a discussion regarding the verdicts, because maybe the verdicts are not meeting the function of motivation. So a work was conducted that was self-restraining to respect the different systems So, do you think that the deontology of comparison can be applicable to regional systems? Thank you. Now I understood your question. Well, thank you very much for your question. It's a very interesting question indeed. And when referring to transplants, we all know that the Inter-American system was a transplanted system. And it was transplanted for the worst reasons. When the Inter-American Convention for Human Rights was adopted, the Latin American region was in the midst of the Cold War. And we needed to offer an image of respect towards human rights. And the Organization of American States, Latin American states, decided to sign the San Jose de Costa Rica agreement. It took many years to have an actual convention that really protected human rights versus so many authoritarian governments. This situation arises in Latin America with the consolidation of democracies that took place in the 80s and in the 90s. That was a wave of democracy that was very important. The problem for comparative law is that there's some assimilation per names. It doesn't matter whether you have the Inter-American system for the protection of human rights. Is it the same type of system as the European system? Because they're both based on a court. But if we bear in mind that the Inter-American system has only produced 500 court decisions, and if we take also into account the budget reluctance of the countries to finance this system, and also we bear in mind that citizens don't have access to the Inter-American system and that everything is done through the Inter-American Commission. And then we see that there are some problems. So maybe you think that I believe that the Inter-American system is useless. No, that's not the case. I believe that it's very valuable. And I believe that it's very important for democratic societies. And what these courts do is also very important. But sometimes juries, when we are dealing with the Inter-American system, we tend to say the Inter-American court said so. But there is a problem there because we have to see what was said, why it was said, whether it was said right or wrong. So it's not enough just to quote in an abstract manner. Simultaneously, we see that something similar happens with the African courts, and it is very different from the European human rights system. It has a different type of process with more transparent bottom-up mechanisms because the countries are committed to develop this system. And both of them, and I believe that this is the crux of the matter, deal with a different idea of the national appreciation, because in Europe there is a respect for the evolution of the legal systems that make up the European Convention, and it's very prudent. And in the Inter-American system, there is this enforceability of the decisions that we should rethink. And rethinking it doesn't mean weakening it, but strengthening it. Because when we speak in terms of comparison, the balance and the perspective of the court is very important. Not for one to follow the other, but just to understand why and when they work differently. In the inter-American system, we have a special way of electing the judges. We haven't advanced at all in terms of how the judges are chosen. However, in Europe, they have taken some steps, consistent steps, so that the judges reaching the court are suitable enough. These are problems that appear in a comparison. If I see the text of the convention and I see the court decision and I don't know who the judges are and what their doctrine is, then I'm not seeing much. But if I do know who the judges are and then I can compare both scenarios, then the conclusions will enable us to strengthen the system. Thank you for your question. We just have 5 minutes left, so we will now give the floor to Professor Carolina Fernandez Blanco. This will be the last question. If you could raise your hand so you're given a microphone. Hello, thank you very much. This conference is very interesting, and the presentation has been very interesting. And I would like to go back to this idea of the transplants, because as we have heard, transplants do have their strengths and weaknesses. And my question has to do with the idea by Max Bollanger, who says that instead of referring to transplants, we should be referring to legal translations. So my question is, what would be the best method, if any, for legal transplants to become a legal tool with the capacity to be tested in each system? Do you think it is possible? Is there a methodology for this, or what would be the associated ideas so these legal translations could be effective and efficient? It's not the same, of course, to have a voluntary transplant or an enforced one or a conditioned one, such as the one of the Washington Convention. The idea or the question here would be, how can we make these transplants a way of setting laws, of passing laws, by having this testing model based on scientific evidence, legal evidence, so we could have effective and efficient legal systems? It's true that the transplant topic is a very interesting topic, and thank you for your question. I would like to recall now an initiative regarding Mauro Capelletti's work, Interpretation Through Law. Because in the past, in the beautiful era of the 80s and the 90s, when we saw this coming about of a democratic Europe, and this integration allowed for cross-fertilization and the adoption of what was happening in other countries. And I think that Europe showed this through a harmonic process. First, the questions were raised before the states, then a consensus was sought. And I think that the legal framework of the EU is very important in this regard. And we have the idea of being able to coexisting with others with no dominance. How do I translate an institution? Well, first of all, I need to make it compatible with my own culture, and I have to know what I'm ready to accept and what I'm not ready to accept, and what are the specific benefits of adopting a specific system. Of course, there are systems that are more suitable than others, and there are institutions that have a better performance, that are performing better. But for this, we need open legal systems, like open societies, open to the experience of others. And of course, we also have to pay attention to the failure of transplant, because that is a burden for society. Because to build something is hard, and to have to unbuild it is even harder. So we have to start with a first question. Why do I think I need what I think I need, and what are the resources available, the material, cultural, and political resources, so that I can adapt everything in a useful way. But this would be a preliminary and simplified recipe of a huge challenge that's very difficult to apply. And you always need to look at many different ways. There's just not one single way. Well, thank you very much, Professor Oteiza. We will end here this first session. Thank you very much, Professor, and I'd like to thank the audience also for the questions. Thank you.